Hey guys, it's Kathy. I hope you're doing well. So, I had to really try hard to stream today. I'm not gonna lie. I did not want to stream it all today after the nightmare stream from yesterday. It was horrible. I should not have streamed yesterday. I mean, we were so busy at work. I worked a double. We were so busy that 10 minutes before we closed, a bus came. And no one even realized a bus came because it was so busy. There were people everywhere for the whole night. I only found out a bus came when they were all leaving because I'm like, one drink and then you guys have to go. We're closed. And then they all got up at one time and left and they were talking about getting on the bus. I'm like, holy cow, that was a bus. I was screaming all night trying to get through people to get drinks to people, trying to scream over the band. But yeah, it was a bad stream yesterday. So I wasn't going to stream today, but I wanted to show this. I wanted to show this case because it's interesting. So what I did when I got off work tonight was I put all my snacks in the house beside my computer. That way, if I want any snack at all tonight, I have to come to my computer to get it. And then I'll stream while I'm here because I promised you guys I'd get this stream out today. So that, my friends, is called being an adult. Put the snacks where you have to go, and then you'll go there. So this isn't like no Karens in this. The lawyers get a little iffy, but it's just an interesting case of a scammer that just doesn't want to pay anybody back. And it's not like $2,000 we're talking about. We're talking about a lot. And he goes from church to church to find these people. So, and I can't mess this stream up. I can't because it's an hour long, so I just won't be talking. I have to talk now or YouTube won't let me post. But that's it. You won't hear from me again until the end. All right, here we go. Let's play it.
That's where the need was, more so than in large churches. As a result, I never had a whole lot. After I quit doing the ministry, I was working several jobs. Sometimes I was working 2 and 3 jobs a week. Uh, I never had a whole lot of money. Um, I fell at work one time and ended up with 9 different back surgeries. As a result of that, I received a settlement, which is where the money came from that I was able to invest with Mr. Johnson. He had all kinds of great plans on how he was going to invest my money for me. He said that I would receive $2,500 a month. I gave him $300,000. He would give me $2,500 a month for 7 years. At the end of the 7 years, then he would take and give me the $300,000 back, or I would be able to reinvest it with him. He confronted me at the European market one day and said, "I see that you had received a settlement in the course that had received a verdict, and wanted to know if I would be willing to invest with him because he had all these plans on how he's going to take that money and spend it and make more money." I agreed with him that I would give him the $300,000, and for a few months everything went fine. I received the $2,500. In addition to the fact that I was now on disability because of all the issues with my back. Uh, the 2 incomes combined seemed to be adequate to where I was able to live, not extremely well, but to pay all my bills and to sustain my life. Uh, then all of a sudden the payments started getting later and later. Then all of a sudden I was receiving nothing at all from him. He continued to have multiple excuses as to why this person didn't pay their rent, this person didn't do this, and all the money wasn't coming in like he claimed it was coming in. As a result, I was getting nothing from him. I was now living strictly on disability, which didn't cover my bills, so I had to end up going back to work, working 2 and 3 jobs again. just to make ends meet. Uh, Very disappointing in going back for a moment, about a month after I had started it with the investment with him. I went into his office one day and here comes Don driving up in a brand new truck. And I thought, and I asked him, I said, is this where my money went to buy you a new truck? And he just laughed, never denied it, but he was driving that brand new truck. It wasn't long after that, all of a sudden, money stopped coming in. It was very disappointing in the fact that I'm now trying to make ends meet. And he's driving a new truck, he's, living in a nice house, at a new pool, all of which seem to think, where is my money at? You're driving around in new vehicles, you're living in a nice home, you've got businesses, and I'm living on disability. It was a very difficult situation for me. I ended up having to move into a trailer, living in that trailer even to this day. The vehicle that I had at the time eventually wore out. I ended up having to buy a used truck just to make in, just to get around. My payments on that now are right at $600 a month. My lot fee is $700 a month. And that barely comes in now with my Social Security. The disability went into Social Security because I've turned at the age where it's now Social Security instead of disability. In fact, as of June, I'll be 70 years old. At a time in my life where I felt like I should be able to start enjoying things, I'm still working 6 and 7 days a week, just to cover my expenses and make ends meet. I have a significant other that we talk about it a lot. Where would you like to go on vacation if we were ever able to afford to go on vacation? We haven't been on a vacation in 10 years. And it's something that I figured at the time when I'm turning 70 years old, I should have been able to take a vacation. The only time I've been able to go out of town was for work, or my grandson received his Eagle Scout this year and also graduated from high school. My daughter paid for me to go out and visit him. Excuse me. One of those things that's not easy to take when your children are paying you to come visit. I've always thought, how would I like for restitution to take place? Don and always, we talked on occasion that he was a preacher as well, that he would give sermons and stuff on occasion when the preacher was gone and that. And I thought, well, death might be a good way for him to go. That way he will stand before his maker and have to answer for what he's done to everyone. No, he needed more than that. Life in prison, being so with someone who would keep him straight. Well, maybe broken kneecaps. That way, every time he took a step, he would realize what he had done to other people and the harm that he had caused them by the things that he was taking. At this point in life, I'm at the point where just restitution. Just give me back what I gave you, and I would be happy. In addition, though, I would like to see $1,000 of community service, where he is having to deal with the reality of what he's done to other people and the harm that he has caused them in their lives. I appreciate your time. Thank you.
Thank you, sir. Rude.
May I have a moment, Your Honor?
You may.
Judge, I don't believe I have any other victims here who want to give a statement.
If any victim wishes to give a statement, they may. As I have done with the first two victims, their names are not made public. The victims are not sworn to testify. The victims are not subject to cross-examination. Under the law and under the Constitution, it's their opportunity to tell me whatever they wish. They have the right to tell me whatever they want, and they don't have to speak. That's up to them. Having said that, are we now done hearing from victims?
I believe so, Judge.
Okay.
If you'd like to give a statement, you may. That's fine.
Go ahead.
When this all started, John was going to our church and he was an elder at our church. He played Jesus Christ every time there was a play. He was a man that I guess I should have known. He's sweet talking and he could talk me into anything. I remember being in Bible study after I had invested in his wife telling me how they bought some land in Cancun, not Cancun, I'm sorry, Dominican Republic. And I'm like wondering, well, he's doing good, he's doing well in his life. So I invested with him. I trusted him, he'd been going to our church for years, done so much in our church. And it was my retirement money. It wasn't nothing as devastating as these other two people because I still was working. But that was my retirement money. Now I'm on disability, was on disability, Social Security now. Could have been using that money. And instead, it was used for his family and for his things. With the false intent that he was going to give me a 30% increase on the money that I had given him. It comes off as being such a sincere person, and to know that his sincerity is false, and to know that he can get into the churches. Wasn't long afterwards I had heard that he got into another church and was trying to talk this other guy into investing. I don't trust him because of what he had done to us in our church. Can't believe that you would do that to the people in our congregation, to the people that trusted you because you were a man of God, but you were not a man of God. And God will take care of my suffering for you. You'll have to answer to him. And you showed this to your children. You showed your children how to be this kind of man you are. And that probably is one of the most hurtful things, because you really, your children were good children. And what did you teach them? How to swindle people. You would have got a regular job. You could have made good money because you are smart. If you wouldn't have dragged this through, all of us through this for so many years, going through so many lawyers, you could have paid all of us our money back and had money for yourself. You could have done that. You could have owned up to what you did. You know you did wrong. But instead, here we are, court, hoping that we'll get at least a little bit of what you took from us. Why? Why would you do that? you know you're gonna meet your maker. Whether you are at all believing in Christ, you know you're gonna meet your maker. Why would you do that? I can't judge you, right? Know that what you did hurt, that it took from my children, that it took from me. And I'm not a wealthy woman. You had no right to do what you did. And that's all I really can say.
Thank you. You may step down. Mr. Ruder or Mr. Brown, any additional
I don't believe so, Judge.
statements? I have not decided whether to accept or reject this plea. The lawyers know that the court's role in a plea agreement is that I may accept the plea agreement the way that it is written, or I may reject the plea agreement the way that it is written. I can't rewrite guilty pleas. My only options are to accept or to reject. I have reviewed a pre-sentence investigation report. The contents of that report are confidential. I have heard statements from 3 victims. Mr. Johnson has a right to address the court if he wishes before I decide to accept or reject the plea. Does your client wish to address the court?
He does, Your Honor.
You may tell me whatever you wish, Mr. Johnson.
Your Honor, I'm truly sorry, and I'm also saddened that I have not been able to repay my friends who loaned me money over 10 years ago. They trusted me and they believed in me, and I've always had every intention to repay them. The 2008 financial crisis and then 15 years of legal actions against me have severely obstructed my ability to do so. I've been told that with this plea, my friends could recover a percentage of their loss from a restitution fund sooner rather than later. Please accept this plea so we can all put this behind us, allowing me to focus my attention now on finding a way to repay my friends to the best of my ability.
So Mr. Ruder or Mr. Brown, as I've said, and as you all know, as lawyers, I can't rewrite this plea. My only choice is to accept this plea or to reject this plea. I have heard a factual basis for one crime that is count 6 in cause number 2217. I have heard statements, not sworn testimony, but statements from 3 of Mr. Johnson's victims. And I appreciate that the work that all counsel did getting this case prepared for trial, because I know I crunched you guys because I said the trial was not going to be postponed again, period. And I know you worked hard. But from the state's perspective, tell me why this plea in this sentence is justice. Tell me why it's fair. Tell me why I should accept this and not reject the plea, set it for trial, see what happens, and then I sentence Mr. Johnson, if he's convicted, to whatever I wish. State.
Thank you, Judge. Your Honor, what is justice is difficult as a prosecutor, I'm sure as a court, as attorneys. So having reviewed not just the alleged conduct involving the three victims that we heard from so far here today in court, having read about the conduct involving a number of other witnesses, conduct spanning from 2007 to 2013, it's easy to believe, and I believe that Mr. Johnson is deserving of a period of incarceration. But that's not the end of my analysis as a prosecutor. A plea agreement, in my opinion, is an acknowledgement of risk on both sides. And if neither side benefits, then that side that does not benefit shouldn't put their signature on it. So in this particular case, as a prosecutor, myself and Mr. Brown had to consider what is our biggest motivation. And while I do believe that Mr. Johnson deserves a period of incarceration, I believe even more that the victims in these cases deserve to get their money back if they can. That's my primary concern. That's my biggest concern. And I believe that Mr. Johnson will be able to pay back, if not all, a good portion of it. And I know that this conviction should allow the victims in these cases, in these counts at least, to apply for compensation. And while it doesn't make them completely whole, I'm not able to turn back the hands of time and make this not happen. And so certainly I've heard and read at least about all the sad stories involving all these victims and how Mr. Johnson's conduct affected them. And it's very sad. But if we, through by way of a plea agreement, can get the victims paid back for what was taken from them, that's my primary concern, and that's what this plea agreement attempts to do. I was talking about acknowledgement of risk, Your Honor. By not offering a plea agreement or not offering a plea agreement that would be acceptable to all parties, including the court, the other option is trial, which Mr. Brown and I were preparing to do, preparing very diligently. But there are risks associated with going to trial, and those risks are amplified when you're dealing with conduct, all of which is over a decade old. The conduct alleged in this case spans, like I said, from 2007 to 2013. Memories fade, evidence gets lost, witnesses don't recall, witnesses spread out and are hard to get here. And although there's a lot of preparation involved in trying to deal with those issues as a prosecutor, there's never a guarantee. And I do tell victims a trial is never guaranteed, because you can go to trial with the best of cases, but there's a jury and you have to present evidence, and those jurors have to decide whether or not to believe pieces of evidence, believe arguments. And also in this particular case, we're talking about some complex financial issues. So the learning curve for any potential juror would be steep. First, you have to teach them about what are securities. Then you have to present evidence, some of which is 15 years old or greater, and then present witnesses from all over the country now to talk about things that happened to them over a decade ago. There's no guarantees, and this plea agreement provides a guarantee to our victims, a guarantee that Mr. Johnson is held accountable for his actions, and depending on what justice looks like for different people, I believe this plea agreement encompasses justice for the victims. Finally, Your Honor, in listening to the victims that have testified here today, Mr. Johnson victimized people. And what this plea agreement does, in addition to placing him on probation for a period of time, trying to get restitution for the victims, and having him plead guilty to one of the top counts, which is some acknowledgement of wrongdoing, it also precludes Mr. Johnson from obtaining a job in the financial sector from here forward. There is language in the plea agreement that talks about if he is able to fully repay back restitution, that he can cut his probation short, that the state might not, that won't object to an early expungement if he's made those victims whole. But that's just it. Those things only happen if the victims are made whole for the losses they suffered at Mr. Johnson's hands. So for those reasons, I believe this plea agreement to be fair. I believe it acknowledges risk on behalf of the state, and it provides some measure of restitution to those victims that are so deserving of it. And I thank you for your time, Your Honor, and I ask you to consider accepting the plea agreement as tendered.
Mr. Shargoff, and again, I appreciate the work that you did, given that the time that you had in order to prepare for trial. So between the time that I appointed you and the time that I set for trial, which again was not going to be moved, you and the state worked hard to prepare for trial. Having said that, and having heard the state's argument as to why I should accept this, having heard testimony from 3 victims, as well as having read correspondence from one, tell me why this plea is justice.
Judge, looking at, I think the PSI is fairly self-explanatory in that when we're dealing with a case, the court knows this, the state knows this as well. Part of the negotiation process involves whether or not this person, the defendant, Mr. Johnson, would respond well to any type of probation, a short term of incarceration. And if the court looks at that PSI, there is no criminal history for Mr. Johnson. I understand this is not taking away certainly from anything that any of the victims have said here today, but keeping him out of custody gives the greatest chance for restitution to be paid back. It allows him to work. It allows him to try and get some funds together to make the victims whole. Now, he does also get a benefit if he does that. But I think as Mr. Ruda indicated, the biggest factor here is that the plea encompasses making the people whose money was taken, making them whole. So I think based on that, Judge, along with the absolute lack of a criminal record on Mr. Johnson's part, I think that the court should accept the plea, given the nature of these statements made in the PSI. I think Mr. Johnson will respond well during his course of probation. And again, it gives the greatest opportunity for him to pay restitution back.
I've thought about this case a lot since the plea was submitted. And again, the contents of the pre-sentence investigation report are confidential, but Mr. Johnson made a statement again today which minimized his actions. Mr. Johnson, there's no one responsible for what you did other than you. Trying to run away from what you did can't minimize what you did to these people. I don't think you understand that yet. Now, as I said, we're all lawyers, but in reality, I think the most common sense statement that I've heard all morning, not to say that the lawyers don't have common sense, but the third person who spoke to the court, whose name isn't mentioned, said this: if the money that Mr. Johnson has spent on lawyers the last 9 years fighting this case, and we know that he spent at least $100 and some thousand with 2 lawyers who withdrew because he wrote that to the court. If that $150,000 was paid in part to each of the victims, maybe we wouldn't be here. This case has done a great job making money for lawyers and a horrible job since 2007 getting the victims repaid. So what I have heard is, don't send me to prison so I can repay these victims. I haven't seen any repayments in the last years. I don't know why repayments are going to magically start. But anyway, So, under the law, I have an obligation to give a sentencing statement. And as part of the sentencing statement, I have an obligation to set forth aggravators and mitigators. Mr. Chargoloff is right in that Mr. Johnson has led a law-abiding life his entire life until he was charged with these two cases. So up until that time, he didn't have a ticket for jaywalking. He led a law-abiding life. He's not addicted to illicit substances. He doesn't do things that he's supposed to do, except commit this crime, the one crime for which he's pled guilty. So as a mitigator, he's led a law-abiding life. As an aggravator, the harm that was suffered by the victims is greatly disproportionate to that which is required under the plea. So I find that there is an aggravator, that is the severity of the crime. And I find that there is a mitigator, that is living a law-abiding life. I reluctantly, very reluctantly, accept the guilty plea. And I'm going to explain why. And again, it goes back not to what lawyers say, it goes back to what a victim says. The victim says, you should have paid us rather than paying the lawyers. It doesn't take a rocket scientist or a lawyer to figure that out. It takes a person who owes people money to pay them. That's all it took. So, Mr. Johnson, actions speak louder than words. And I'll say that again because it's true. Actions speak louder than words. I don't actually place a lot of value in what you say. I place value in what you do. So you told me that you're really sorry for committing the crimes. You just said that this morning. If you really were sorry, you would have done something since 2007 to pay them back. You haven't. I don't believe that you're sorry. So we heard Mr. Brown when I asked him, why should I take this plea? And he explained the risks of going to trial, which is something that lawyers understand. So in my view, why did you plead guilty? My view is this. You did everything you possibly could for 9 years to delay the trial. Finally, when it got to the point where I said, we're going to trial, no more delays, period. At that point, you had two choices: plead guilty or go to trial. You pled guilty. I don't necessarily like the sentence that's imposed. And as I've said a number of times this morning, if there is a guilty plea and if there's a sentence that's agreed to as part of the plea, I don't get to rewrite that sentence. My only choices are to accept it or to reject it. So again, I think actions speak louder than words. If you really felt sorry for these people, you would have paid them something. So you told me, and we're gonna get into your ability to pay in a second. But you wrote a motion to the court asking that I get your money back, $150,000. I think that you paid attorneys Hammerly and Trada, saying that they basically didn't deserve the money. Well, I find that they did, in that they worked hard to write good motions and argue good law, that they lost. They lost they lost here, and they lost within the Court of Appeals on 15 of the 17 cases. They lost because that was the law. But that's money that could have been paid to the victims, not to lawyers. The criminal justice system isn't designed to make lawyers rich. It's designed to repay victims. So now, at that hearing, I will remember this forever. At the hearing, when you asked to be repaid the fee paid to the Indianapolis lawyers, I swore you to tell the truth. I asked you about your sources of income. I swore you to tell the truth, the whole truth, and nothing but the truth. What did you tell me? You told me half of the truth. You forgot to tell me about the income that you had from a building in Chesterton. I think you forgot to tell me about one of the bankruptcies that you had filed. But what didn't you tell me? You didn't tell me the whole truth. You can't mislead me, Mr. Johnson. Now, the one count was pled in such a way to get around the statute of limitations. And this was all argued in the Court of Appeals and here. So the argument in this court was this. You structure a deal, or you say you're going to be paid after the statute of limitations has run purposefully to get around the statute of limitations. Or in one of the witnesses' cases today, to pay that person some money for some period of time to make it appear as if you're going to do what you said, which was false. And what one of the victims said today is that you had the audacity. I mean, the audacity, you had the courage to ask somebody for more money after you've taken all that she had. That's what she testified. That takes courage. Let me say it again. Actions speak louder than words. I don't care what you say because I don't believe you. So, as part of the plea agreement, you have agreed to pay back $604,500. And at the same time, you claim to not have any money. I find that interesting. And if you have $604,500 now, where's it been the last 12 years? So this plea, and the only reason why I'm accepting this plea is this. It's kind of like a carrot and a stick. I talked about common sense. Now I'm talking about how you train a dog or something. But the carrot is this. The plea agreement says this specifically, that if you pay the amount of restitution, the state agrees to terminate your 4-year probationary sentence, which is a tremendous benefit to you. If you pay the victims, then you'll no longer be on probation, which is a tremendous benefit to the people sitting in this room, so they get paid, which is what they've asked for. And it's also a great benefit to you, because at that point, you would no longer be on probation. Because if you violate the terms of your probation, you could then go to the Indiana Department of Corrections for 4 years if you violate the terms of your probation. So what it does is it gets the victims paid if you have the money. That's the carrot. The stick is this. While you are on probation, if you violate the terms of your probation, you could be sentenced to any part, including your entire 4-year sentence in prison. So there is a carrot in a stick. The state is right in that this plea creates a tremendous incentive to actually get the victims paid for the first time in 12 years. So is it fair? I don't know. Is it the best that can happen today? I think so. The plea perhaps creates incentive to finally get the victims paid. And the plea also creates an incentive for Mr. Johnson to live a law-abiding life or go to prison while he is on probation. So, is this plea fair? Is this plea just? I don't know. But I think it's the best that can be done. And therefore, I reluctantly accept the plea. The plea says this. The plea says that the defendant would be sentenced to 4 years in the Indiana Department of Correction, which would all be suspended except for the time that he's already served in the Porter County Jail. The plea says that if Mr. Johnson pays the restitution in full, then his probationary sentence could be terminated. The plea also says this, that upon payment of restitution, the state will not object to Mr. Johnson filing an earlier than allowed petition for an expungement. The law regarding expungements on C felonies is this. The law is that you're not allowed to petition for an expungement until your sentence is completed and a number of years have then elapsed after your sentence has been completed. In this plea agreement, the state is allowing Mr. Johnson to file an early petition for expungement. Because this is a level C felony, that is not a petition that will be automatically granted, nor is it a petition that will be automatically denied. The decision to grant or deny a petition for expungement is within the sole discretion of the court. Probation's trying to get in. So is the state now moving to dismiss the non-pled counts?
Yes, Judge.
The state's motion to dismiss is granted. I accept the plea agreement the way that it is written, again reluctantly. I enter judgment of conviction under count 6 in short cause 2217, violation of broker dealer registration laws. I sentence Mr. Johnson to 4 years in the Indiana Department of Corrections with all but time served suspended to formal probation with fees. He receives credit for 3 actual days served in the Porter County Jail. In the event that the defendant fulfills all financial obligations in this matter, including but not limited to full payment of restitution, the state hereby agrees at that time to a modification of the terms of the defendant's sentence to release him from probation upon full payment of all restitution. Moreover, the state agrees to a time period earlier than that allowed in Indiana code regarding an expungement of this conviction from the defendant's record, contingent upon the defendant's full payment of all financial obligations related to this case, including restitution. However, all other remaining provisions of the relevant expungement statute shall apply to the defendant's petition. As part of this plea, the defendant agrees to pay restitution in the amount of $604,500 to individuals set forth in the plea. Do I need to name them in the amounts?
No, Judge.
It is in writing in the plea. Mr. Johnson has agreed to pay $604,500, and that payment then would trigger the early termination of probation, as well as allow the filing of a petition for expungement. Again, that petition is discretionary within the court. It is not a mandatory grant or deny. Because I have ordered now as part of the sentence restitution in the amount of $604,500, we need to conduct an examination as to whether or not your client has the ability to pay that restitution amount, Mr. Charlotte.
Judge, I believe Mr. Johnson's previously been sworn.
He has?
Mr. Johnson, may I approach for an exhibit sticker, Judge?
You may.
Thank you.
Raise your hand.
That's what having you with the mark for identification purposes is defendant's group exhibit 1. Can you tell me what those documents are?
These are my tax returns, my federal tax returns for the years 2018, 2019, 2020, 21, and 2022.
And are these copies, aside from the redactions that have been made with the social security numbers and names of minors, are those true and accurate representations, excuse me, of your 2018 through 2022 federal tax returns?
They are.
Judge, I defense will move to admit these as group exhibit 1.
Any objection?
No, Judge.
Defendant's group exhibit number 1 is, you may stay there, sure.
Thank you. Judge, I don't have any further questions for Mr. Johnson, just at this point, just argument based on my exhibit.
You may,
Judge, given,
Could I be heard on evidence?
you may.
The record, judge, the state was not in possession of any of these prior to this hearing. This was all information gathered after he accepted the guilty plea agreement. The flash drive containing the exhibits. Yeah. I have about 33 exhibits I need to go through, judge. Also, for the court and for the defense attorney. sentencing memorandum exhibit list. All these records are either publicly available or within the.
Judge, I object. I object.
All right.
33? Seriously?
I'll note that they all, but I believe one set of them, around 10 pages, were within the defendant's control.
No, defense would move at this point to continue the hearing regarding restitution, Judge. This is ridiculous.
Okay, all right. And Mr. Shargaloff, is this the first time that you've seen this document?
Sentencing memorandum, correct.
Okay, so here's what we're gonna do. The conviction for count 6 in cause 2217 stands. Mr. Johnson, you are now a felon. You have been convicted. You are now on probation. The state has now tendered what appears to perhaps be voluminous records regarding the defendant's ability to pay. I assume because this, right now, we're only addressing the matter of whether or not Mr. Johnson does or does not have the ability to pay. This is information that Mr. Shargaloff has just seen. His objection is well taken. But rather than delay the entry of the sentence in the conviction, I'm entering the conviction now. And we're simply going to continue the hearing on the ability for him to make restitution, because that's all that this addresses, correct?
Yes, Judge. None of these records have anything to do with the crimes that Hanny took the president's ability to pay. Part of our reason for not disclosing that the earlier judge was because after my argument and presenting them today, I think it'd be clear that the defendant has a history of hiding assets and hiding his income. And I was worried about an early disclosure and what would happen to those assets or income. And I'm still worried about it today, Judge. If we continue this hearing, I do have real concerns that some of this might disappear. And that was part of the reason I felt like I couldn't disclose it at this point.
Could have been disclosed to counsel, Judge,
And that would have been disclosed to the defendant.
with the caveat from the state articulating their concerns. But I'm not going to sit here today, Judge, with 33 exhibits and argue blindly my client's ability to pay.
All right, so hold on. So there's a remedy to that. So you think, Mr. Ruda, that if whatever is contained in the state's sentencing memorandum is disclosed to Mr. Johnson, that he's going to secrete or hide or get rid of these assets?
Judge, I do have real concerns about that. They said if I could be heard a little bit on it.
Well, I tell you what, we can give him an opportunity to convict himself further and send himself to prison for 4 years right now.
Judge, what we pulled was, like I said, all publicly available records from the Porter County, not Marion County, Porter County Recorder's Office, Porter County Assessor's Office, Porter County Treasurer's Office, the only and his own bank accounts for his accounts that he currently has. So if he didn't provide those to the defense attorney or didn't tell him about properties that he owned, that is on Mr. Johnson, not on the state. And it's not on Mr. Shargaloff either. It is on Mr. Johnson. If he wants to deceive his attorneys about what is going on, what his assets are, what his income is, that is on Mr. Johnson.
Well, I can take care of that right now.
There's only one set of records, and it deals with a mortgage companies dealing with the property in question, Judge, that would have needed to be subpoenaed. Everything else is something Mr. Johnson could have gone and requested, or told Mr. Shargaloff to go and request. And even in regards to those records, CoreLogic, they're a payment processor for mortgage companies. That is something, if Mr. Johnson had disclosed to Mr. Shargaloff, hey, by the way, I have interest in all these properties, that is something Mr. Shargaloff could have gone subpoenaed. If he chose to deceive his attorney and not tell him about any of these properties or his income, that is on Mr. Johnson.
So
Judge, if I may, one brief response.
you may.
If the court is going to continue the hearing regarding restitution, which I strongly urge the court to do, my position at this point would be the court's order to essentially not liquidate any assets from Mr. Johnson until that time would be sufficient. The court, because the sentence has been imposed today, Judge, could make that a term of his probation until the hearing.
That's what I was gonna do. And invite him to do that, because if he does, you're going to prison for 4 years.
Judge, additionally, I would just like to clarify, because we have played word games as far as what property he's derived income from. He didn't mention his Airbnb.
It doesn't make sense for him to try to play word games with me anymore. Let me,
I just want to be clear, some of these properties, he's not, his direct name is not on it, but the records indicate that he has ownership interest in them. So I would just ask that those be included, and that way down the road, we're not, well, I don't technically own that, a trust owns it, and I'm the trustee of that trust.
all right. So here's what I'm gonna do. First thing I'm gonna do is to talk about the 4 purposes for incarceration. The purposes of incarceration are this. The first purpose is to protect society from people who are criminals that prey on them. If you're in prison, you then can't hurt people who aren't in prison. That's the first purpose. The second purpose is to rehabilitate criminals. The third purpose is to deter criminals from further action. And as we sit here now, I don't remember what the fourth one is. Here's what I'm saying to you, Mr. Johnson. Don't test me. If you do, I can't prejudge anything, but I've just sentenced you to 4 years in prison. If you sell any asset that could be used to pay these victims, and I learn of that, we will then have a hearing on a petition to revoke your probation. The person that's on the screen there is your probation officer. If you violate the terms of your probation, and I find that you do so, and the state proves that by the preponderance of the evidence, I can sentence you up to the entirety of your sentence. Do you understand?
Yes, sir.
Does it make sense to deplete, sell, transfer any asset in any way that the state could argue would send you to prison? Does it make sense to do that?
No.
Judge, to be clear, that order is until the point of the hearing, correct?
I'm gonna set a hearing real soon. All right, it's just like I said before, we're not letting this thing drag out. And in fairness, I understand the state's perspective that we don't want to lose evidence. I understand. But Mr. Shargoloff is also right, is that you can't spring this on me and then expect me to rule on it. But my sentencing order stands. The conviction is in place. You are now a felon. The only aspect of the sentencing order that isn't complete at this time is repayment as an indigence, the ability to pay. Mr. Shargoloff's point is well taken. He's just seen this. I understand the state's perspective as to why they've just revealed it. So in the meantime, I am ordering Mr. Johnson to not sell, transfer, give any asset that he has any ownership interest in, any beneficial interest in. If it's held by a trust and you have some benefit under the trust, what are the state's concerns, other concerns?
Judge, he receives a large amount of income from from rental properties not disclosed to this court. His business bank account, for example, has deposits monthly of $20,000 to $40,000. In the last 3 years, between his business account and his personal account, over $1 million has moved through those accounts. And
Has $604,500 gone through those accounts
over that amount, Judge.
that could have been used to pay restitution?
Yes, Judge. And so our concern at this point is him switching bank accounts, a sudden deplete, switching the bank accounts. I have sent a subpoena to Airbnb, so if he is using them, he also does a lot of transactions on Venmo and PayPal as well. There's several $100,000 on that as well. So he could be using Venmo or PayPal to accept payments for
Judge,
rentals instead of.
I didn't receive any third-party notice, because that's a third-party subpoena.
All right.
Yeah.
We're not actually, what I want to find out now is how it is that the state thinks that Mr. Johnson's gonna deplete these assets before we have a hearing. And I'm gonna say this, so here's my order. Don't deplete any asset between now and the hearing. If you do, I will find that you're willfully violating my order and you're willfully trying to avoid paying those people. Don't challenge me. You will lose.
And Judge, I'll note the subpoenas were issued through our administrative court. We have independent civil regulatory authority over securities laws and securities matters, separate from what we have here. In fact, we have civil authority to, no matter what happens with this criminal case, to pursue him civilly.
Judge, I'd also like an order that the state can't produce any additional exhibits before that hearing, or at the time of this hearing.
So what we're doing is we're gonna have a hearing soon that does two things. It allows you time to review that which the state has just provided to you. And it's soon so that assets cannot be depleted. So if there is an asset that should be used to pay the victims, it will be. Does everyone understand?
Crystal clear, Judge.
Yes, Judge.
Nothing's fine. The court did this. The case that was set for trial next week was continued yesterday. The case that's set for trial in a week was affirmed yesterday. So what that means is we could have a trial or we could have a hearing on restitution in these assets next Thursday or Friday. Or later, with the understanding that the order to not deplete the assets remains in place, with the caveat that I'm going to be in trial the week of the 12th and in trial the week of the 19th.
Go further, Judge.
We,
22nd, 9 a.m.
so the Abduli trial is off.
Going to be.
We could do it Tuesday, February 20th.
That's fine, Judge. I don't believe I have anything on my calendar.
That's fine, Judge. What time, Your Honor?
9 o'clock.
Your Honor, if I may, would we be able to do just an hour later than that?
Yes,
Thank you.
we could do it February 20th at 10 o'clock for a hearing that's limited to the assets that Mr. Johnson has to pay restitution. In the meantime, the order says this: the state can't spring any more assets. Spring's not the right word.
Blindside, harpoon. I could certainly, plethora of words, Judge.
Wow. Word salad was, if you find any other assets, you must turn them over to Mr. Shargoff immediately. Immediately. And Mr. Johnson, in the meantime, you and those people that you have control over. So you can't do this. You can't say, I can't sell this, so I then direct somebody to sell it on my behalf, and then you can't say, see, I didn't sell it. Don't try me. Matter is now set for hearing on the defendant's ability to pay restitution, February 20th at 10 o'clock. You are now ordered to report to probation, sir. That will be all.
All right.
Well, who thinks this guy's going to jail? I do. Who thinks he's going to sell assets? I do. Who thinks he's smarter than the judge and the prosecutor? I do. I don't know if I'm going to be able to get this case on the 20th because this is one of those that's not it's not on YouTube. It's not recorded. You have to catch it live. And you know, they say it's going to be at like 10 o'clock, but that's never the case. They call cases early, they call cases late. I worked, so I'm going to try to get this hearing to see if he sold any of his assets. I think he's going to. I think he's going to get caught, and I think they're going to take him away in cuffs. Because I think that he doesn't want to pay the people that he said lent him money. Nobody lent him money. They invested with him. He said that he would, give them a good return. That's not lending someone money. Who lends someone $600,000? Oh, if any of you do, you should talk to me. Hit me up. I need $600,000. I don't know what for yet, but I'll do something fun. I know. I will buy a hamburger sofa, a hot dog sofa. I saw a hot dog sofa today for like $8,000, shaped like a hot dog, and a chair that goes with it shaped like a hamburger for a couple $1,000s, which is crazy. Yeah, prosecution. Well, guys, thank you for coming back out. Appreciate it. I hope you guys have a good Lightfoot. I think you're tomorrow. You're like PM right now, like 1:00 PM. Is that right? Well, we're 3:00 AM yesterday for you. I hope you have a good time in New Zealand. I hope the Foo Fighters were great, and you can't hear today because your ears were blasted out. I start my weekend now, so I will talk to you guys when I get more stuff. Have a good day.